Welcome. Welcome, and thank you all for joining us from different time zones across the globe. My name is Eitan Diamond. I'm the manager of the Diakonia IHL Center in Jerusalem. And my colleagues and I are really excited about hosting this session. And we're extremely grateful to the wonderful speakers we're privileged to have with us. We want to thank them for agreeing to do this. I'll introduce each of the speakers before they present, but before turning to do that, I want to provide a few words of background about this event. So moments ago, actually, we completed the 6th and final session of the new IHL training series that we inaugurated this spring. And today we also launched a new publication, an easy guide on international humanitarian law that's designed to serve as a kind of reference for professionals working in occupied Palestinian territories. We've convened this event in part to commemorate the completion of these projects, but also to address some lingering concerns that they have not fully addressed, neither the training nor this guide. The concern that in a way haunts all of our work. And what I mean by that is the question of what practical benefit does the law that we go to such pains to elucidate actually bring? Does it make things better? Can it make things better? Does it perhaps make things worse? These are really existential questions for international lawyers and for humanitarian and human rights professionals working in this context, and I suppose in others as well. And so my colleagues and I do have some answers to these questions, but we feel that we could benefit a great deal if we could kind of shore up these answers by drawing insight from a group of experts with rich and diverse experience in applying the law and appealing to the law in an effort to affect change, in positive change for Palestinians. And the panelists that we have with us today certainly form such a group. And I hope and actually trust that we will learn a lot from them. Each of them will speak for 15 minutes, and all going well, we'll have a fair amount of time for a Q&A and discussion afterwards. While the panelists are speaking, please feel free to raise questions in the chat function, and we'll make an effort to respond to those during the Q&A. In the Q&A, we'll also give people an opportunity to speak directly, raise their questions directly. So without further ado, I'm going to introduce our first speaker, and that is Professor Michael Lynk, Canadian national and professor of law at Western University in London, Ontario. He teaches labor law, constitutional law, and human rights law, and has also written widely on these subjects. Importantly, certainly for the purpose of this panel, Professor Lynk is also the Special Rapporteur on the situation of human rights in occupied Palestinian territory, a position he has held since 2016. In this position, Professor Lynk has investigated and issued comprehensive reports on a host of issues relating to the human rights situation in occupied Palestinian territories. And these documents don't just report on the gap between the law and the reality on the ground, but also contain concrete recommendations about actions that need to be taken by various actors in order to close this gap. We're hoping that Professor Lynk might share some insights about these efforts to make the law deliver on its promise. And without further ado, over to you, Professor Lynk. Thanks again for joining us.
Thank you very much for having me. It's a distinguished panel, and I'm very honored to be part of it. I'm going to show in my 15 minutes some slides that will illustrate my particular assignment for today, which is to talk about the Israeli settlements and international humanitarian law. So I'm going to share my screen now, and if you can just confirm, I think it's there, is it not?
It is.
Very good. Okay, thank you so much. Very briefly then, as a quick lesson in law, the Israeli settlements, which there are roughly 250 settlements now in East Jerusalem and the West Bank, they come under international humanitarian law and more recently under international criminal law. The founders of and the creators of the Geneva Conventions of 1949 adopted as part of their project the Article 49, paragraph 6, which said that the occupying power shall not deport or transfer parts of its own civilian population into the territory that it occupies. And this arose because of practices in the Second World War by the instigators of that war of clearing lands, particularly in Eastern Europe, of their settled populations and moving in their own civilian populations in order to be able to expand their borders and to create the basis for annexation. In a major report that was delivered to the United Nations in 1993, excuse me, the Economic and Social Council of the UN stated that did a major review of settlements and settler implantation, and said that the range of rights violated by population transfer and the implantation of settlers places this phenomenon in the category of mass violations of human rights. This is all cumulated in the 6th occasion by which the UN Security Council has pronounced on the legality of the settlements, a resolution in December 2016, where it stated that Israel's settlements are a flagrant violation of international law. They have no validity under law, and they must stop immediately, and they're also a grave threat to the prospects of a two-state solution. And I also want to point out, and this may be discussed later on during this webinar, that under the Rome Statute passed in 1998, creating the International Criminal Court, the world community identified civilian settlements in occupied territory as a war crime, building on what they had done in 1949 with the Fourth Geneva Convention and in 1977 with the additional protocols there. Many of you would be familiar with these facts with respect to the Israeli settlements. They're the primary Israeli tool in order to have demographic domination of the occupied territories, in particular East Jerusalem and the West Bank. There are at least 250 Jewish-only settlements in the occupied Palestinian territory, the population of which amounts to coming close to now 700,000 Israeli settlers. The settlements grow by around 20 to 25,000 settlers each year, and as well, in addition, there are another 20,000 settlers in the occupied Golan Heights belonging to Syria. The Israeli settlements control a significant part of the West Bank. They're concentrated in what is known as Area C, and they control, as the statistic shows here, 42% of the West Bank, not only where the settlements are actually placed, but also through the intensive road system that winds up connecting the settlements to each other and separating the Palestinian communities from one another, as well as establishing easy access by transportation into Israel itself. And the years, certainly over the last 5 years, and particularly in 2020, saw the greatest growth with respect to the approval of settlement housing units by Israel. Peace Now said that 2020 was the highest year on its record since it began maintaining these statistics in 2012. The UN High Commissioner for Human Rights has identified in yearly reports to the Human Rights Council the significant human rights impact of the Israeli settlements on the Palestinians, including land confiscation, discriminatory planning laws, the demolition of Palestinian homes, and shrinking territorial space. Obviously, the placement of the settlements throughout the West Bank and East Jerusalem, the obvious political intent, and it's been stated many times by a succession of Israeli leaders, is to prevent the ability of the Palestinians to form their own viable state contiguous on a contiguous territory in Mandate Palestine. The two biggest issues, and I'm sure they'll be spoken about later on this morning as well, with respect to the impact of the settlements, is first of all differential rights and laws. The the 700,000 Israeli settlers living in East Jerusalem and the West Bank enjoy vastly different and vastly superior political, social, and economic rights to the 3 million Palestinians living among them in East Jerusalem and the West Bank. There are settler-only roads. There's a settler-only power system, a settler-only water system. There are different courts. There are different rights to be able to express oneself through voting. The other aspect of this, obviously, in human rights terms, is the denial of self-determination. And this, as I said, if the settlements are the engine of the Israeli occupation, then the primary purpose is to scatter Palestinian settlements throughout the West Bank and East Jerusalem, and to deny them the effective right of self-determination. And I may remind you that self-determination is actually Article number 1 in both of the 2 1966 international covenants. It's, if you like, the first among equals. The international community, by stating that, is saying that none of the other rights, economic rights, political rights, cultural rights, social rights, are realizable without having self-determination. So the denial of self-determination is the denial of the whole other basket of human rights contained in modern international human rights. It's impossible to talk about the issue of the settlements, indeed most other aspects of how international law applies to the Israeli occupation, without talking about the issue of accountability. Eitan mentioned that I issue 2 reports a year to the General Assembly and to the Human Rights Council. 2 of my most recent reports in October 2019 and October 2020 address the issue of accountability, or should I say the lack of accountability in international law. And I would point out, particularly with 3 main areas of international law and its application with respect to Security Council resolutions. On the laws of occupation, the Security Council has said in 22 different resolutions beginning in November 1967 that the 4th Geneva Convention on the rights of protected persons under occupation applies in full to the Israeli occupation of the Palestinian Territory. Similarly, with respect to annexation, the Security Council has stated on 11 occasions since 1967 that the acquisition of territory by war or by force is inadmissible. Indeed, this is a cornerstone principle for the creation of the United Nations in 1945, expressed in Article 2 of the Charter of the United Nations. And these 11 resolutions, all of them are making specific reference to Israel's occupation. And thirdly, with respect to what I'm speaking to you this morning about, the Security Council has said on 6 different resolutions since 1968 that the Israeli settlements are illegal under international law and a flagrant violation. And I mentioned to you that the most recent reiteration of that was UN Security Council Resolution 2334, adopted by the Security Council in December 2016. None of these resolutions that I'm referring you to have been obeyed by Israel. And as Gideon Levy, the esteemed columnist for Haaretz, has said, no country is as dependent on the support of the international community as Israel, yet Israel allows itself to defy the world as few dare. If I can point to you what the international law says with respect to accountability, first and foremost, and this is at the very heart of international humanitarian law, common article number 1 of the 4 Geneva Conventions of 1949 state that the high contracting parties undertake to respect, but also to ensure respect for the present convention in all of its circumstances. This is placed in number 1 in all 4 of these conventions because the international community recognized that not only was it necessary to state what modern law was, but there had to be some form of accountability that international members of the Geneva Conventions would actually commit themselves to obey and promise to obey these conventions, not only for themselves, but if other countries who are signatories to the Geneva Conventions would therefore take united and cooperative tasks to find a way in order to ensure that those disobedient countries would bring themselves back into alignment with the requirements of the four Geneva Conventions. This has been reiterated later on in the 2001 articles on state responsibility. And as well, I point out to you that in 1945, in Article 25 of the Charter of the United Nations, the world agreed that members of the United Nations agree to accept and to carry out the decisions of the Security Council. So this means by belonging to the United Nations, you're making an explicit promise that you will obey Security Council resolutions. And if I can close off or begin to close off with this, I've often in recent weeks in webinars gone back to UN Security Council Resolution 476 from the end of June 1980, which means this is almost 41 years ago. The Security Council adopted this resolution, and it said three things that I think are important for us to keep in mind. First of all, the Security Council pointed out that even though at this point when the occupation was 13 years old, it said that there was an overriding necessity for ending the prolonged occupation of Arab territory since 1967. Secondly, the Security Council said it strongly deplored the continued refusal of Israel to comply with the relevant resolutions of the Security Council and the General Assembly. And thirdly, it said that it reaffirms its determination that Israel continues to not cooperate with the Security Council and to remain in defiance of Security Council resolutions, that it would examine practical ways and means in accordance with the Charter to ensure Israel's full implementation of the present resolution. This particular resolution had to do with the impending illegal annexation of Jerusalem. So what I can say is this, is that the 54-year-old Israeli occupation stands out today as being paradoxically both thick with laws and also quite lawless. There is no other long-standing conflict in the modern world where the international community has so frequently pronounced on the many principles of international law, which are to govern the administration and the endpoint of the occupation, and yet where the dominant state has been so defiant and the international response has been so limp. International law is not meant to be an umbrella that folds up when it rains. So if the international community had determined that Israel's occupation of Palestine by 1980 was already prolonged and was already a matter of overwhelming necessity to end, and if Israel had already demonstrated by 1980 its unwillingness to comply with the explicit directions of the Security Council, because it was confident that no consequences would follow, then how are we to understand this situation 4 decades later? According to statistics from Peace Now, in 1980, there were 12,500 settlers in the West Bank. By 2019, there were 441,000 settlers, 35 times as many. So if realpolitik, the discarding of international law, and the absence of accountability have brought us speeding past the last exit to a two-state solution, then shouldn't the next attempt to relaunch a serious peace process be anchored instead in the agreed upon national and individual rights-based approach that would govern both Palestinians and Israelis? Thank you very much.
Thanks very much, Michael. I hope we'll have an opportunity to explore that further in the Q&A, because there's a lot of food for thought there. Our next speaker is Sari Bashi, who currently serves as Research Director at DAWN, the acronym for Democracy for the Arab World Now. Sari is a human rights lawyer and expert in international humanitarian law, and she is co-founder of Gisha, a human rights organization based in Israel that focuses on freedom of movement for Palestinians in Gaza. Sari directed Gisha for 9 years. She later served as Israel-Palestine country director at Human Rights Watch, and has taught on the Israeli occupation of Palestinian territory and on international law at various places, including at Yale Law School, of which she is an alumnus. Sari is also a writer. In addition to valuable contributions to legal scholarship, She has worked as a journalist and is the author of a recently published book, Makluba, Upside Down Love. The book, so far published only in Hebrew, describes Sari's experiences as a Jewish Israeli American married to a Palestinian resident of Ramallah. Describes their experiences as they raise two children and try to lead ordinary lives in what she describes as an extraordinary and unforgiving reality. I think that Sari has a uniquely rich personal and professional perspective from which to reflect on the question we have posed for discussion, and look forward to hearing what she has to say. So over to you, Sari. Thanks again for joining us.
Thank you so much. It's an honor to be part of this distinguished panel. And especially I want to thank Eitan. I think that you represent a really rare mix of theory and practice throughout your career. And so I can't think of a better person to convene this discussion, which is supposed to talk about how we can bring theories into practice for enforcement. So what I'd like to do is to talk a little bit about an emerging framework that I think can supplement and to some extent maybe surpass IHL as a narrative framework of accountability, and that's the Apartheid Framework. This is just some preliminary thoughts. I'm very much looking forward to the discussion afterward, which I see as a kind of strategy session as to how we can move forward to actually make changes on the ground. What I'd like to do is consider how we might encourage the use of apartheid as a dominant narrative, political, and also legal framework, while still maintaining international humanitarian law, IHL, as a short and medium-term enforcement mechanism, which I think is very important. So I'll start by suggesting that the apartheid framework is becoming increasingly prominent in discourse among important actors involved in Israel-Palestine. I'm going to suggest some advantages that that framework brings, and then conclude with thinking how we might use it together with IHL to actually get better results on the ground. So first, in terms of apartheid, disclaimer, a lot of the way that I'm going to present the apartheid framework is linked to the Human Rights Watch report, which was recently published, concluding that the crime of apartheid is being committed throughout the space of Israel-Palestine. The disclaimer is that I was a consultant helping them publish that report, and I've worked with Human Rights Watch in the past. I also want to acknowledge that while I'm going to be adopting the definitions and interpretations of apartheid from the Human Rights Watch report, that report and every other discussion of apartheid builds on over a decade of work by Palestinian human rights groups, especially Al-Haq, Adalah, the Palestinian Center for Human Rights, who as far back as 10 years ago found that apartheid existed and made very detailed legal and factual findings to support that. And in recent years, more actors, including B'Tselem, including Human Rights Watch, including politicians, are adopting that roadmap that was laid out 10 years ago by prominent Palestinian human rights lawyers and activists. So I want to talk a bit about the elements of the crime of apartheid. Apartheid is a crime against humanity that's defined in the Rome Statute that gives rise to the International Criminal Court. And it's also defined in a 1973 Convention on Apartheid. It has three main elements. One, and maybe the most important one, is an intent to maintain the domination of one racial group over another racial group. And that takes place, this is the second element, in the context of systematic oppression. And the third element is through the commission of one or more inhumane or inhuman acts. And just to be clear about racial group, the way that racial group has been understood in the relevant international instruments and courts is an ethnic group. So there's a very local definition. In saying that, I'm not suggesting that Jews or Palestinians or Muslims or Christians are a race, but these are groups that have very strong local salience, and that's relevant for the definition of the crime. So these are the elements of the crime. There's been recently a breakthrough in a growing consensus that those elements are being met, at least in some parts of Israel and Palestine. I mentioned the Human Rights Watch report, but Selem and Yeshkin, two Israeli human rights organizations, recently also came out with reports finding apartheid. Apartheid is also starting to enter into popular discourse. So you have John Oliver, a clever comedian, satirist. You have Saturday Night Live. You have increasingly mainstream journalists talking about apartheid as a relevant and somewhat accurate framework. And even within Israel, even within the United States, you have people to some extent debating to what extent it's apartheid, where is it apartheid, but it's a legitimate question now. It's a legitimate issue right now, and that's new and different. And I think to some extent, it's just the fact that, many years of building, of laying out a framework by Palestinian human rights lawyers is coming to fruition. And that's just takes time to build that. But I also think that it's becoming so dominant because the intent element of the crime has become more and more clear and transparent. And I'll just say a little bit more about that. In recent years, as the Israeli political system has gone into a growing tailspin with increasingly fascist elements gaining sway and a lot of neutralization of responsible adults who kept up a veneer of legitimacy for Israeli laws and policies, one thing you've seen is much more clearer statements about why the government is behaving in the way it is toward Palestinians. So in 2018, the Israeli Knesset passed the nation state law, which first of all says that Israel is the locus of self-determination for Jews and Jews only, although 20% of the population are Palestinian. And it also defined Jewish settlement as a national priority. There have also been more clearer statements about what the government is trying to do. So, for example, you could see that in the passage of the citizenship law in 2003, which bars family reunification for Israeli citizens who marry Palestinian residents of either Gaza or the West Bank. And in most cases, it prevents Palestinian citizens of Israel from reuniting with their Palestinian spouses in Israel. So it does two things. It prevents more Palestinians from coming into Israel and getting status. And it also has the effect of getting rid of Palestinian citizens of Israel and residents of East Jerusalem, because the only way they can be with their loved ones is to leave the state of Israel. So you can sort of see the evolution of that intent by looking at that policy. The policy preventing family reunification started informally as a series of bureaucratic obstacles by the Ministry of Interior, that in theory, if you were a Palestinian citizen of Israel, you could get your spouse to come. It was just really hard, and you'd be thwarted at every turn, and individual security claims would be raised against your spouse. In 2003, a law was passed that categorically bans all family reunification, but it had a security rationale, and that's how it actually it was upheld in the Supreme Court, that this is for security purposes. But since then, you've had a lot of leakage of just Israeli politicians saying the real intent. So Israeli Prime Minister Sharon in 2005 said, look, there's no need to hide behind security arguments. We need a Jewish state, and that's why we need to ban more Palestinians from becoming citizens. And yesterday the Likud had an interesting tweet. They were criticizing the new government for not being able to renew that law, because it's a temporary law that just by chance has been renewed for the last 18 years. And so in their tweet, they said, this law is needed to prevent tens of thousands of Palestinians and unlawful infiltrators from getting citizenship, which would destroy the Jewish state. So pretty much clear acknowledgement, this is a demographic policy to maximize, to prevent more Palestinians from coming, as part of a broader policy to maximize the amount of land throughout the space from the Jordan River to the Mediterranean Sea that's available for Jews, and where we can put Palestinians in isolated enclaves where we've given up on Jewish settlement. So another kind of thing that's become clear is, as that policy has become more advanced in the West Bank, and Michael talked about the settlements, that's that. It's harder to ignore that that's what it's about. Also in Gaza, and here I give credit to Gisha and other groups that have persuasively shown that the closure of Gaza, the very strict restrictions on movement into and out of Gaza, are actually part of this policy to maximize land for Jews with a minimum number of Palestinians Palestinians. And the way that works for Gaza is you make it really hard for the 2 million Palestinians to leave Gaza. And you also, by not allowing family reunification, create inducements for Palestinians from the West Bank and Israel to enter Gaza. So you take those 2 million Palestinians off the democratic equation, the demographic equation, leaving much more land for Jews, Palestinians and enclaves, Jews in the rest of the space. There's similar policies in Jerusalem, which has become more obvious, but there's an official policy to have a 60% Jewish majority in the city, and that's done by displacing Palestinians, including from East Jerusalem, which is occupied territory. And even inside Israel, there are policies to Judaize the Negev and the Galil, which accounts for 2/3 of the land of the state of Israel and much of the Palestinian population. So it's become increasingly clear that the IHL violations we're seeing are part of a much broader policy, which is about Jewish domination and Jewish demographic superiority over Palestinians. So why is that helpful? Well, I think the apartheid framework is more salient in many ways than the IHL framework. The IHL framework is a temporary framework. IHL is an emergency mechanism, which is very permissive in terms of the kinds of abuses that a state can perpetrate against the people it's controlling militarily. But that's because the occupation is supposed to be temporary. And sure, IHL has mechanisms to keep an occupation temporary. Prohibition on transfer of civilian population, settlements, prohibitions on forced transfer of the local population, ban on the exploitation of natural resources, limitations on confiscating property. But those mechanisms have not been enforced, and there's no prospect for them to be enforced. Apartheid essentially says, well, actually, those mechanisms that are making the occupation permanent, that's inherent to what the government is doing. So it's not just about, the problem is not just that the occupation is not temporary. The problem is that this is part of a broader policy of Jewish domination over Palestinians throughout the space. A second advantage that I think the apartheid framework brings is the ability to talk not just about what happened in 1967, but also about what happened in 1948. So IHL relates primarily to the problem of 1967, which was the start of the military occupation. And it feeds what I think is a false sense that if we create compliance with IHL or even end the occupation, if we go so far as to say that IHL can now maybe make the occupation unlawful, then everything will be okay. But it won't be okay, because we still have the problem of refugees in Israel, in the OPT, in the diaspora in Israel. We call them displaced persons who are not allowed to return to their homes in violation of international law. And also Palestinians in Israel, the institutional discrimination against them is not just some coincidence. It's part of this broader governmental policy. I think that the apartheid framework has the potential to better bring in human rights law, even beyond the extent to which international humanitarian law can bring in human rights law. And the reason is that it can more effectively address the question of discrimination, the right of return, discrimination inside Israel, Palestine, but even discrimination within the occupied Palestinian territory. Because IHL has struggles to deal with the question of discrimination, because IHL says there should be discrimination between the protected persons and the civilians of the occupied territory, and the civilians of the occupied territory shouldn't even be there in the territory. But once they are, how do we talk about that? I think apartheid discrimination is inherent to the apartheid framework. And that framework can more effectively let us talk about that kind of very fundamental discrimination. The last advantage that I think apartheid brings is the question of movement building. IHL is technical, it's non-intuitive, it's not very helpful in terms of building a movement. Apartheid, people get it. Discrimination, it's very communicative, especially in the West, in Europe, in the United States, where increasingly local movements against discrimination are seeing themselves as in solidarity with discrimination against Palestinians in Israel and Palestine. And that's helpful. I also think that the framework better resonates with Palestinian lived experience. It can help bridge between activists and lawyers and the technical people, because most Palestinians, I don't want to speak for them, but there was a recent poll that found that 77% of Palestinians in Gaza and the West Bank believe that the situation either somewhat or completely resembles apartheid. That's what people are experiencing. And perhaps if we talk more about apartheid, we'd be better able to bridge activist movements on the ground and what the lawyers are trying to do. I think also for the Israeli left, there's a potential to have a more effective mobilization. The Zionist left within Israel is in crisis because the Zionist left wants to hold together a Jewish and democratic state. And as the state becomes less democratic, some of them are just going over to the Jewish side, but others are really struggling. And I think the apartheid framework encourages them to recognize that the problem is not just the occupation, that there's other things that need to be addressed, namely discrimination against Palestinians and the right of return of Palestinian refugees. And as hard as that recognition is, it's necessary if there's going to be an effective, broader movement built. Ultimately, the difference between apartheid and IHL is in the goal. If IHL is being violated, then we should have compliance within the occupation or even end the occupation. And if conduct of hostilities rules are being violated, then we should have peace. So apartheid actually says, no, the goal is not just peace or ending the occupation, the goal is justice. And that might be a more effective mobilizer. I want to conclude with some thoughts about how the apartheid framework might interact with IHL. I think IHL is more effective in terms of bringing short and medium term restraints, enforcement mechanisms. So the recommendations to address the crime of apartheid is to dismantle the system, change the laws, transform the legal and political system to end policies of Jewish domination. The IHL framework is much more immediate. Don't bomb this house. Don't build this settlement. And we need that. We need that clarity. I also think in terms of criminal law, I think it'll be a long time before the apartheid framework is actually implemented in criminal law. And I think that we've made a lot of progress in terms of getting serious attention to the war crimes of the settlements and possibly some conduct of hostilities violations in Gaza. Also in terms of third parties, and I know there are a lot of Europeans on this call, I think that especially there's been a really good foundation for getting the EU to recognize its obligations not to be complicit in IHL violations, whether that's settlement products or bilateral agreements or businesses that have obligations not to be contributing to IHL violations. And we should keep that momentum. We should keep those enforcement mechanisms. I want to suggest that we might be able to have apartheid as a normative framework that is dominant as a mobilization, also as the way we understand what's happening, while still maintaining IHL to set limits. And I know my time is up, but I'd be happy to say more about that in the discussion.
Thanks very much, Sari. Yeah, I hope we'll have time to discuss further in the discussion, because obviously there's a lot to reflect on there. Thanks again. Our next speaker is Chantal Meloni, who is a professor of international criminal law and criminology at the University of Milan, and also a senior legal advisor at the European Center for Constitutional and Human Rights on International Crimes and Accountability. In addition to academic pursuits, Professor Meloni has put her expertise in the field of international criminal law to practical use, including on issues relating to the Palestinian-Israeli context. Among other things, she has worked with the Palestinian Center for Human Rights in Gaza and is currently representing Palestinian victims in her capacity as an assistant counsel for the International Criminal Court in The Hague. So as such, I think Professor Meloni is really well placed to speak about efforts to seek redress for violations of IHL that constitute international crimes, and really looking forward to hearing from you. Thanks for joining us.
Thank you, Aitan, for inviting me. I'm really glad and also honored, honestly, to be in such a panel and talking after Professor Lynk, Sari Bashi, who I got to know many years ago when I was in Gaza in 2010 and visited Gisha to collaborate on some issues, and of course Hassan, who's been a friend for many years. So thank you so much I think these events are of critical importance, even if there might be a feeling that everything has been said with regard to Israel-Palestine, the occupation, the crimes, the violations, the settlements. It's never enough. And it's very important that we speak about this situation from a legal perspective. So I think really it is very, very important what Diakonia is doing. And in the few minutes that I have, I will try to reflect on the role of the International Criminal Court on the situation. And of course, as Eitan said, I will do this from the perspective of someone who's not only studying this, but also working on the situation that is currently open before the International Criminal Court, representing Palestinian victims, together with the lawyer Raji Sourani, who is also the director of the Palestinian Center for Human Rights. So if you want, the overreaching question for me is whether international criminal law, and specifically the ICC, can fill this gap and break the circle of impunity that we heard about, in particular from, from Michael Lynk. Because in this too long conflict, in this crisis situation, the violations of international law that have been committed by Israel over all these decades have been basically left unpunished from the point of view of state responsibility, human rights, and international humanitarian law, strictly speaking. Already in 2009, at the end of the fact-finding mission that had been established by the UN after the so-called Operation Casled, probably you remember the head of that fact-finding mission, Richard Goldstone, had written with the mission very important words on the fact that there was an impunity crisis in the region that fosters violence, and there was therefore a need to break the circle of impunity and bring alleged perpetrators to justice, also resorting to instruments of international criminal law, including the International Criminal Court. And this is exactly the perspective that I will also follow, considering that actually the dichotomy that is often presented between peace versus justice is not a dichotomy, because there is no achievable peace which is not based on a just resolution. And of course, nothing is possible to achieve when you have two parties, like in the present instance, when one is clearly an oppressed people, victimized since decades and in a very weak situation, and on the other side you have a very powerful occupier that is supported by every possible means internationally from the outside by other states. So I think it's useful to have a look at what is actually ongoing at the ICC at the moment. And I will try to do it also highlighting what, in my opinion, are the biggest limits or obstacles of the ongoing proceedings before the ICC, which I identify basically in three different issues. The first one being the timing of these proceedings. The second one, the approach so far taken, which is quite narrow. And the third one, the political distortion that is threatening such an investigation. So with regard to the basic of the investigation that is now open before the ICC, maybe a few words to say how we got to have an investigation, first of all, open before the International Criminal Court. Maybe not all of you are aware that the formal opening of the investigation before the International Criminal Court is very, very recent. It was announced formally by the prosecutor only in March 2021, so 2 months ago, 3 months ago. And this has been the result of a long process, which goes back to 2015, now with the opening of the preliminary examination after the Palestinian Authority in January 2015 ratified the Rome Statute, and also in 2017 lodged a referral, so technically a document signed by the state, the Palestinian Authority in this case, requesting the ICC prosecutor to investigate the situation of alleged crimes, war crimes, crimes against humanity committed on the Palestinian territory. But this was not the first time that Palestine had tried to trigger an investigation before the ICC, because already in 2009, after the already mentioned Operation Casled, the so-called Operation Casled, the Palestinian government had, so to say, knocked on the door of the International Criminal Court, filing what is called an ad hoc acceptance of the Rome Statute. Under Article 12.3, it is possible for a state not to ratify the statute in its entirety, but nevertheless to accept the jurisdiction of the court so that the court can ad hoc initiate an investigation. And this was done, as I said, already back in 2009, and it was really also urged by the international community, including in particular the UN through the Goldstone report, which had been basically confirmed by the UN General Assembly. And then there were several resolutions and declarations taken at different levels at the UN, but also in the European Union, at the European Parliament, for instance, and of course, also coming from individual states. So already at that time, there was a 3-year-long preliminary examination, which was closed in 2012 by the former prosecutor of the ICC, Luis Moreno Campo, with a very short statement saying basically that the ICC prosecutor was not able to decide whether Palestine was a state or not under international law, and therefore was not able to open this investigation. And then fast forward, what happened in 2015 is that in the meantime, the UN General Assembly, as you probably know, on 29th November 2012, basically upgraded the status of Palestine before the UN, including it next just to the Vatican in this special position as a non-member state. So from that moment, the prosecutor of the ICC basically made it clear that if Palestine ratified the Rome Statute, they could have been accepted. And this happened, as I said, in January 2015. So from January 2015 till March 2021, what happened in these 6 years? Well, there was a process that is called preliminary examination. What is a preliminary examination? It's something that before the ICC comes before the opening of a formal investigation. So it's not yet a criminal investigation. It's an analysis. It's a preliminary analysis, and it is aimed at filtering out basically allegations of commission of crimes which are prima facie unfounded or outside the scope of the jurisdiction of the ICC. So basically the Office of the Prosecutor analyzes the information available, gathered open source material without using its investigative powers yet, but of course collecting all possible information, and then decides whether the situation is solid enough and warrants the opening of a formal investigation. So this is what happened in these past years. And already in December 2019, actually, the prosecutor came to the conclusion that the allegations were serious enough, were substantiated by reasonable grounds to believe that war crimes, crimes against humanity had been committed, and that for the interest of justice, also taking into consideration also the interest of victims, it was necessary to open an investigation. But instead of deciding directly to open this investigation back in December 2009, she wanted to put the question before the pretrial chamber to get a sort of judicial confirmation that her interpretation of the criteria, and in particular the territorial jurisdiction of the court, were confirmed by the judges of the ICC. This was not, strictly speaking, a needed procedural passage. It would have been possible for the prosecutor just to open the investigation. There was no need for any authorization because Palestine had referred the situation. There was no need for a passage before the pretrial chamber. But nevertheless, because of many reasons that now I don't have the time to elaborate, but maybe in the Q&A we can talk about it, she felt strongly that it was better to get this judicial authorization. And at the same time, she had requested the pretrial chamber to decide within 120 days, so 4 months. And these 120 days became 14 months, so 1 year and 2 months. And in the meantime, there was a very complex process that involved almost 50 participants, including many states, 7 states, Amici Curie, organizations, scholars, and also, of course, legal representative of lawyers like myself and Raji Surani. What is striking is that these 7 states that participate in the proceedings, who are Germany, Austria, Hungary, Brazil, and I'm not sure at the moment who are the other 3, they all basically participated in order to say that the ICC should not open the investigation on Palestine because Palestine is not a state under international law, and therefore the investigation is not legitimate. And this position is very, very, very honestly criticizable from the international point of view, because what it's important to note is that the ICC, of course, is an independent body, has its own judicial competency, and it is able to determine its own jurisdiction, which means that when the judges confirmed that Palestine could be considered as a state in front of the ICC, they didn't, of course, have the intention to decide once and for all whether Palestine is a state under public international law. But what they said is that for the sake of the jurisdiction of the court, Palestine is a state. In fact, it is a member state since 2015. It is a member of the Assembly of the State Parties, and therefore the court can have jurisdiction on its territory. So now, just concluding on this, because I see my time is almost over, I just want to mention the other 2 points that I indicated as problematic from my point of view. The first one is the narrow approach that has been taken so far by the ICC prosecutor. And here, it is very important to consider what Sari was saying before me, the apartheid, and I would add persecution, because also this Human Rights Watch report is on both crimes, apartheid and persecution. So we need to get out of the rhetoric of the war crimes, where there are 2 parties fighting one against each other, and basically they are in a sort of equal level, where war crimes are committed by both sides. From the perspective of Israel, of course, armed groups in Palestine are also committing war crimes when firing, for instance, rockets from the Gaza Strip. And also the prosecutor of the ICC has already signaled that she is going to investigate these allegations of crimes committed by the Palestinian armed groups. and also by the Israeli army, of course. But again, this attempt to consider the two parties equal and to have a balanced investigation is very problematic from the point of view of what we were talking about before. And as I said, these political interferences, which are very strong, unprecedented on the court. Not that I think that the court will bound under these political pressures, but there is a distortion of arguments. And I think in this, and here I conclude, it's very important to remember what the pretrial chamber now said in February by deciding that, in fact, they had the jurisdiction on Palestine and saying, of course, this is also a political situation, as every basically situation before the ICC, because when we are talking about the commission of war crimes and crimes against humanity, they involve state apparatus, they involve the highest echelons of a state, they are political in itself. But there is also a legal dimension, and this is what we will deal with. This is what the ICC will deal with, individual criminal responsibilities for the allegations of very grave crimes committed on the Palestinian territory. So thank you very much, and sorry for being a bit too long.
No, that was fine. Yeah. Thanks a lot, Chantal. Yeah, the problem is each one of you, there's enough for, there's so much to discuss about each one of these presentations, and we'll have to try and condense it all in the few minutes that we have at our disposal at the end. We'll have it. But before doing that, we have one more speaker. Last but not least, Dr. Hassan Jabareen, who is the founder of Adalah and has served as Adalah's director since its establishment in 1996. Hassan has litigated many landmark cases before the Israeli Supreme Court, including many cases concerning Palestinians in the territory occupied by Israel since 1967 and concerning Palestinian citizens of Israel. The recipient of several awards for his contributions to public interest lawyering and the promotion of human rights, Hassan has also made notable contributions to legal scholarship, having published and taught extensively. Law's influence over the experience of Palestinians in their interactions with Israel, whether as citizens or residents of the occupied territory, has been a central subject of Hassan's work as a practitioner and of his scholarship. He is consequently supremely well placed, in our view, to reflect on the question of whether IHL, international law, and perhaps law more broadly, is fit for purpose to address concerns about Israeli practices and policies towards Palestinians. So over to you, Hassan, and thanks for being with us. Hassan, we can't hear you. Perhaps you're muted.
Yes.
Okay.
Hi, thank you, Ethan. And I am happy to be in this panel with very old friends that we work together and we share ideas together and we support each other. And always we are meeting in crucial moment of the law, whether the moment of the ICC, the moment of the ICJ, or the rise of the new discourse about the apartheid. So I want to follow what Sari started. And if I want to choose title of my talk, I will choose the place of the Palestinian citizen of Israel in the international law. We know that the IHL discourse has been dominant strongly in the last decades. And we notice that, in fact, after Oslo agreement, that started to be dominant than ever. And this discourse create and contribute to the creation that Israel is managing two legal systems. One legal system on the Palestinian OPT of 1967, and one within the Green Line. One in the Green Line, which is democratic system, and one that should obey the IHL norms. In fact, this discourse that emphasizes the IHL try to show that the two systems, one is foreign for each other. But in fact, not only that one system is foreign to each other, but we have two different peoples that foreign to each other, the Palestinians and the occupied territories of 1967, and the Palestinians, citizen of Israel. Lately, we started to see and to be noticed for a new discourse. In December 2019, for the first time, we saw that the concluding remarks of Sir put aside the rhetoric and the use of the IHL norms and emphasize the question of discrimination. And it looks to the whole territory in the Green Line and beyond the Green Line as one territory where the Palestinians live under racial segregation, meaning for the first time, we notice that there is a report that referred to Israel as one legal regime and the Palestinian people as one unit of analysis. Not two units of analysis, not the three, but one, that they live under Israel regime and they face racial discrimination and systematic racial discrimination. In fact, those remarks came due to lobbying and work internationally after the pass of the nation-state law. The nation-state law creates a constitutional moment, locally and internationally. Of course, we can say that the articles of the nation-state law didn't bring any new things. Israel always defined itself as state for the Jewish people. Israel always put the Palestinian citizen of Israel as second-class citizen. However, this law put those values on the level of constitution, and it's not temporary, it's not as a matter of practice, but the Israeli constitution put it strongly in this level. Now, if we compare the nation-state law as a law that put the Israeli constitutional identity in the constitutional level, we saw that almost there is no constitution in the world that put such a value as a nation-state law, where it declares that we, the people, is not we, the citizen of the state, but we are the ethnic people. So this aspect allows to compare Israel legal system to the apartheid system and to the period of segregation in the United States and other racial states that they define themselves constitutionally as ethnic state. So this discourse opened the way also to start to view Israel as managing one legal system, because also, as Sari said, the nation-state law is not applying only to the Palestinian citizen, also it applies to Palestinians live in Jerusalem, and also to the development of Israel system. So this is why it was easy for CERN to come with its concluding remark that we saw it as revolutionary and different than any remarks that we faced in the past. In the past, we saw that said make distinction between the IHL question and constitutional question. When it discussed Palestinians in the OBTs of 1967, it applied IHL and tried to see how Israel creates two systems in the West Bank against the IHL. And when it refers to the Palestinian citizen, it discusses question of constitutionalism, that they are facing racial discrimination. So for the first time, we saw that there is a UN body that refer to the territory as one unit of analysis and the Palestinian people one unit of analysis. Now, after that, and lately, the last development that we are witness is the UN Council decision the last May to establish a commission of inquiry about the last events. Now, for the first time, UN Council established commission of inquiry that includes the status of Palestinian citizen of Israel. And for the first time, there is a commission of inquiry after a war that not only refer to Gaza or West Bank or Jerusalem, but also to the Palestinians inside Israel. So again, this decision could follow the decision of SER that to look to the Palestinian people as one unit of analysis that they live under Israel regime. So those aspects, of course, came on time that we were witness to the report of Human Rights Watch and B'Tselem that put the question of the apartheid as direct question that came and beyond the division of two legal systems, one democratic system and other that should respect the IHL. Of course, Palestinian is a human rights organization. Before this report of Human Rights Watch also referred to the question of apartheid, but the effect of the Human Rights Watch was stronger than others, and maybe also because of its timing. Now, what's that mean to start to refer to the regime as one regime and to put the question of domination, racial segregation in systematic way, and the inhuman treatment of the Palestinians, that all of those factors put the question of the apartheid directly. This aspect, of course, will affect strongly the discourse of the IHL. And it will face difficulties. We know that the PLO and the Palestinian Authority and most of the states still on the project of two-state solution. So this matter, of course, will give power to the continuation of the IHL. Second, also that we know that the first immediate result or impression or idea come after you put the question of apartheid is the remedy. The remedy of apartheid that people should be equal. The demand of equality should be the central demand. But we know that the Palestinians, West Bank, Gaza, and Jerusalem, they don't demand equality before Israel legal system. They don't want to be equal with the Israeli Jews. They don't want in Hebron to be equal with the settlement. So of course, this is a very, very difficult matter because it's not enough that we as lawyers speak about the apartheid when you don't have national movement, popular movement to struggle for equality. Another aspect that comes always, that question of apartheid might give the impression that the only solution of the conflict is a one-state solution. And also, we cannot see easily that in the partitioning of the Palestinian people for very, very long time, Gaza, Jerusalem, West Bank, Green Line, that easy to have this popular struggle against apartheid and for full equality. The question of equal rights move us from question of national conflict to civil conflict. And this issue, not the two peoples are ready to prepare for. However, the discourse might continue, which start lately, be among the elite international lawyer. And I think that by itself is very, very important. It's very important to examine this question. And of course, we can say always that apartheid, and to say that Israel regime is apartheid regime or carry serious feature of apartheid, it's a matter of describing the regime. However, we don't put what's the final political remedy, whether one state, two states, or three states. So this matter of saying that this regime is apartheid mostly goes off the describing of the regime, but the description itself has normative consequences. You describe a regime in this way, so what's that mean in legal? It will mean that crimes of humanity will become irrelevant. So what I want to end, that we cannot speak about apartheid without bringing the Palestinian citizen of Israel on the forum, because without that, we will be limited on the question of West Bank, Gaza, and Jerusalem, whereas the dominant question is not apartheid, but IHL, because the Palestinian people there have the struggle for a long time, and the only popular struggle there is against the occupation and for ending the occupation. The only way to put the apartheid question is to portray Israel as one legal regime, as one legal system, and the Palestinian people as one legal unit of analysis. If we notice, for example, to my friend Chantal talk, we notice how much she used the term Palestine. And for her talk, because she is with the IHL, the name Palestine refer only to West Bank, Gaza, and Jerusalem, meaning even the IHL succeeded to change the language of us as Palestinian people. When in Arabic we say Palestine, we mean the whole territory, including at least in to name the geography, to include also the Green Line. But the IHL even divide the language and divide that territory. So I see the apartheid discourse is a challenge of the IHL. Maybe we don't know how the IHL and the apartheid will go together, but at least the apartheid discourse, I think, will stretch questions that belong to the IHL. Thank you.
Thank you very much, Hassan. So we have about 15 minutes for questions. So, and we received a few questions in the chat already, but what I'm going to try to do, because we won't be able to go through all of those questions, and I still want to offer an opportunity for some other people in the audience to raise questions, is to summarize or generalize some of these questions. And perhaps there are two areas there that one can refer to. Some of them really came out, I think, from what Hassan was just saying. So the first line of questions that I'll put is something like this. So as Michael indicated in the outset, there's clearly a failure of political will on the part of states to take action to put an end to violations that have been identified and to, as Chantal put it, break the cycle of impunity. Now, so I suppose the question was, are the efforts that have been described, the change of discourse, the shift towards a rhetoric of apartheid, and also efforts to promote individual accountability through international criminal law, are these really ways that this problem of a lack of political will can seriously be challenged? Can they sidestep the absence of political will on the part of states? Can they deliver concrete results? And a little bit more specifically, so when it comes to international criminal law, can individual responsibility, even if it were established, really change structural concerns? Because the concerns that Michael spoke about before are really structural. And when it comes to reframing and using a discourse of apartheid, can this serve in some way to overcome the political resistance that exists among states? Can that deliver results that are beneficial for Palestinians? So that was one set of questions. And then generalizing again, another one that was really, I think, quite apparent from certainly from what Hassan was saying, was about the relationship between the political solution that was debated for a long time, so a two-state solution or this whole discourse about the end result politically. How does that relate to these avenues for actualizing the law or for using the law as a tool? So how does, for example, the discourse on apartheid relate to the two-state solution? Is it a shift that's a result of people giving up on that kind of political solution? Can it somehow coexist with that kind of a vision? Chantal spoke a little bit about arguments that were raised about the kind of political debate in the background and how that affects international criminal law. So those are, I'm trying to put together a few questions. Those were general themes that emerged from the questions. And so I'd like to throw those to whichever one of you really wants to take them up. And then perhaps we'll have a moment to take up another question from people in the audience. I don't know who wants to go first. You're also welcome to respond to one another, of course.
You know, I could just maybe generally say that I think that the apartheid framework has potential because it has the potential to help break through this focus on a peace process at the expense of looking at what's happening on the ground. So I think a lot of very important actors have said, okay, we understand there's all these human rights violations and we don't like them when we talk against them, but the most important thing is that we have a peace process for a two-state solution. And that's been going on for the last 3 decades at least. And it's been extremely unhelpful. And so I think what the apartheid framework does is say, well, actually, no, these temporary things that are happening are not temporary. And we actually need to address the root problem. In terms of building a popular movement, I think that's where we need to be focusing. And I think apartheid has the potential to mobilize people in a way that IHL doesn't. And just to be clear, we're at a very early stage of actually getting justice. I mean, this is, I don't know how many years or decades, but this is not going to happen tomorrow. And we need to be building a movement around a new narrative framework. And I really appreciated Hassan's analysis of where the Palestinian movement for liberation is. There had been a national movement for national liberation, and it's dying or it's dead. And so there's now a chance and a need to reconstruct it. And already you see young people in Gaza, in the West Bank, talking about rights And every time they try, they get knocked down by either Israel, Hamas, or the Palestinian Authority, but they're trying to talk about a rights-based framework, and that's kind of where we need to go. And just in terms of what we could ask of right now from states, so apartheid is a crime against humanity. And in the same way that we ask states, for example, not to contribute to the war crime of settlements, we also need to ask them to check their bilateral agreements with Israel to ensure that those agreements are not contributing to the crime against humanity of apartheid. The same is true for US military and financial assistance to the Israeli government, and also for businesses to check. And here's a broader recommendation for businesses. Don't just evaluate whether your business activities contribute to the war crime of settlements. Check also whether they're contributing to the crime against humanity of apartheid. And that's a much broader recommendation.
If I can jump in just to add to what Sarah has said, nobody should be surprised that we're now talking about apartheid as a analytical and legal concept with respect to what's happening in Israel and the occupied territories. The international community created the modern framework for international humanitarian law, international human rights law in the 1940s. And since 1967, it's proclaimed its application of IHL and IHRL through hundreds of resolutions coming from the Security Council, the General Assembly, and the Human Rights Council. And yet it has consistently recoiled from imposing any accountability measures or any insistence that Israel had to comply with the dictates of the international community and its obligations as a rights-bearing state in the international community. When you think of the various initiatives that have begun for the last 30 years, as Sari has referred to, beginning from the 1993 Declaration of Principles through to the 2013-14 Kerry initiatives, and I'm going to leave the Trump plan it's another story. But none of these peace initiatives would ever use the rights-based approach and the steady legal scaffolding of international law to guide with how the principles of and the final status issues of Jerusalem, refugees, settlements, borders, self-determination were going to be used. They were all absent, primarily because Israel had insisted that an international framework based on law was not going to be used, and the United States agreed with it. So what that resulted in was that Israel was allowed to be able to treat all of these core issues as items to negotiate rather than principles of law by which it had to comply. So instead, realpolitik has shaped all of these peace initiatives from 1993 onward, enabling Israel to be able to bargain from the strength of its many facts on the ground, its illegal facts on the ground. And this, therefore, it's my argument, I think it's probably shared by everybody on this panel, that the lack of a sturdy rights-based approach has been the primary reason why all of these peace initiatives over the last 30 years have failed.
Thanks very much, Michael. I see Chantal has had her hand up for a while, so I'm going to pass over to her now.
If I can unmute, sorry. Yes, just quickly, I think what is needed is an integrated approach that takes into consideration several levels of international accountability, one of them being international criminal responsibility. And I mean, international criminal law, and so the criminalization of international humanitarian law, for instance, violations, is, as you know, the strongest level that the law can provide protection to a protected interest, protected goods. It has a symbolic effect. Criminal law bears with it a very symbolic effect. And sometimes, to get even one, if it is a high-level perpetrator, and we are talking about higher echelons, of course, we are talking about possible political leaders who gets under investigation for serious crimes, bears with it a transformative, like a change, even in a political situation. So here is where I believe that if the ICC does its work properly, which we will see in the next, not even months, years, there is a possibility that some issues become even, you know, from an international point of view, more clear, and it is going to be increasingly difficult to deny that some practices are ongoing in Palestine, and that they have to be tackled from the perspective of international law and accountability. Having said that, I don't think apartheid framework or IHL are necessarily in contrast. Also, apartheid is not only a crime against humanity, it is also a war crime. And apartheid also bears another level of responsibility, which is a state responsibility. We have a UN convention, we have an international convention prohibiting apartheid that is speaking to states. So again, we need an integrated approach, which also involves grassroots. And of course, it's not only in the hands of the judges, and it's not only for sure in the hands of the states.
Hassan, over to you. I see you.
Yeah, of course, the apartheid framework came with a package of kinds of rights. It's not just the rights-based approach, but there is special kind of rights, and mainly equality. I don't see the Palestinian people are struggling for equal rights with Israelis. I don't see that there is legitimacy among the Palestinians to the settlement and to the continuation of the settlement. Yes, there is serious question that the move from the IHL to apartheid, meaning two people lives under one regime, we can say, of course, a remedy can be otherwise, but also we have to think about the immediate effect of that. IHL continue to say the settlements are illegal. The move to the apartheid mean let us live with the Israeli Jews in the settlement. We can say until tomorrow that we are just describing, but when you put the framework and this framework become dominant, the comparison with South Africa become dominant, and the rights approach, the right-based approach will be the dominant. The failure of us as Palestinian lawyers is that all the time we try to speak in the language that the Western lawyers accept. So apartheid is easy to speak to Western lawyers about it because you speak on civil rights language, inequality right. But if we look to our discourse as Palestinian people, we don't use the terms of apartheid or IHL. The only framework that we speak about is colonialism. And we didn't succeed to develop legally the framework of colonialism beyond the question that decolonization means the exercise of the right of self-determination of people. So, of course, when we say that the two framework, apartheid and IHL, fit to the situation, we are saying that the situation is colonial situation. I see that we as lawyers, human rights lawyers, if we want to speak to the struggle of the people, we also need to develop the legal consequences of framework of colonialism. This is the only language that I see it among the Palestinian people. This is the only popular language that I see it. This is the only description in that the people in Gaza, West Bank, Gaza, in Haifa, in Nazareth, in Al Fahim, that describe Israeli regime. And this approach doesn't put and bring specific language of rights that you have to follow it. It put directly the question of the right of self-determination of the Palestinian people. It might also bring questions of not civil rights also, but group rights. It solves many issues regarding questions of one state, two state, three states. So this is one of the difficulties that we, the Palestinian human rights lawyers, didn't succeed yet to contribute to the international law, to bring back the framework of colonialism as it was in the 60s in the war. One of the reasons for that, because all the time we want to speak to language that fits constitutionalism, fits language of rights, but we know that the discourse of colonialism came from the South, from the East, because it was followed with popular struggle. I can say until tomorrow, Israel regime is apartheid. I won't find one person in Gaza or in Hebron ready to submit case to the Supreme Court asking for equal rights between him or her and Israelis. This is, of course, a gap. I am not saying that we have to solve it within this panel, but to be aware about it, to be aware about the language of law that we use and the language of the popular movement. I agree with Sari that Palestinian people in Gaza, youth, and in Haifa and in Nazareth, today they are demanding rights, but they put the right of human dignity first, which is, I think, close, and this is what they mean, close to the framework of colonialism that fit their description to the situation that they live. Because the main thing of colonial regime usually is targeting the right of human dignity of the people or the natives.
And so I'm sorry, I have to, I would be really happy to listen to this more, but we actually have exhausted our time, unfortunately. So we're left with a lot of food for thought, but less time to speak about all this. I will point out that while we haven't yet taken up the question of colonialism at Diakonia and how that interrelates with IHL, we have commissioned an expert opinion that's available online that has begun to look at the interplay between IHL, the law of occupation, and apartheid. It was clear from the discussion that there's some tension there, but this relationship is quite complex, and the expert opinion tries to shed some light about how these two legal regimes can interrelate. And I suppose the next project will have to be colonialism and how that fits into the picture. But we have to draw to a close now because we've exhausted our time. So really, I want to repeat the thanks to the panelists for a really enlightening and fascinating conversation, which creates a strong incentive to continue the conversation. So we'll have to think of another forum to bring you over again. Thank you all, and thanks to all the people who attended the session.
Thank you.
Thank you.
Aitan, next time you have to plan 3 hours.
Yeah.
Because I am sorry not to have the time to reply to all these questions, but
perhaps I should put, we'll collect the questions, we can share them with the panelists, and perhaps we'll try and provide, on our side, we'll try to provide an answer. We might consult with you if you want to comment on the answers that we provided.
Thank you so much for organizing this.
Thank you.
Bye-bye.
Take care, everyone.
Thank you.
Bye.